We'll begin this morning with case 2013-250, State of Arkansas versus Jamie Shoemaker. Shoemaker, you're present for the purpose of changing your plea on the charges, is that correct?
Yes, sir.
And this change of plea is brought about by an agreement that's been worked out for you by your attorney, Mr. Bailey, is that correct?
Yes, sir.
Have you discussed the terms of the agreement and the punishment you're to receive with your attorney?
Yes, sir.
And do you feel you understand the terms of the agreement?
Yes, sir.
And are you satisfied with the advice and the representation that Mr. Bailey has provided you?
Yes, sir.
On the charges in this case of possession of a controlled substance, Roxicet, that's a Class D felony, possession of drug paraphernalia, Class D felony, possession of controlled substance, Class A misdemeanor, and endangering the welfare of a minor, a separate Class A misdemeanor. How do you now plead?
Guilty.
You're in this plea of guilty pursuant to the agreement we've been discussing. That agreement is set out in writing in this document I'm holding up called a plea statement. Have you read through and signed this plea statement?
Yes, sir.
And in doing so, do you feel you understand what's set out in writing in that statement?
Yes, sir.
You then understand the nature of the charges against you and the full range of penalties you're facing?
Yes, sir.
You also understand from that plea statement then that there are certain rights that you give up or surrender by pleading guilty?
Yes, sir.
The most important of those rights you're giving up are the right to a trial by jury, the right to be represented by an attorney and have the assistance of the attorney at trial. You're giving up the right to confront the witnesses that would appear and testify against you at trial, and you're also giving up the right to appeal. Do you understand these rights that you're giving up?
Yes, sir.
And understanding what you're giving up, are you still willing to enter a plea of guilty?
Yes, sir.
Are you pleading guilty here today freely and voluntarily?
Yes, sir.
Has anybody in any form or fashion forced you into entering this plea?
No, sir.
As you enter this plea here today, are you acknowledging the truth of the accusations against you?
Yes, sir.
Basically, you're acknowledging that on or about the 16th day of October of 2013 here in Mountain Home that you had in your possession a quantity of Roxicet, quantity of paraphernalia for the use of that drug. You also had in your possession a quantity of marijuana, and all of this was in proximity to a child.
Yeah.
All right. Based on those statements, the court at this time will find that the defendant has freely and voluntarily entered her plea of guilty, done so after consulting an attorney, and has admitted to the facts that constitute the crime. In this case, on that basis, the court at this time formally accepts the defendant's plea of guilty, finding the defendant guilty of possession of controlled substance, Class D felony, possession of drug paraphernalia, Class D felony, possession of a controlled substance, a Class A misdemeanor, and endangering welfare of a minor, a Class A misdemeanor. In accordance with the agreement in this case, the court is sentencing the defendant on the two D felonies to 6 years of supervised probation, subject to the standard terms and conditions of probation of this court. On the two misdemeanors, the court is sentencing the defendant to 12 months of probation, once again subject to the standard terms and conditions of probation of this court. Those sentences will run concurrent with each other. The court is providing the defendant will pay court costs in the amount of $200, the fine of $1,000, the statutory DNA fine of $250, a drug crime assessment of $125 and a booking administration fee of $20. All of those amounts will be due and payable as a term and condition of the defendant's probation, payable at a minimum rate of $100 per month, beginning within 30 days of this date. That will be the order of the court. The court is reviewing at this time the written terms and conditions of probation which are attached to the plea statement. Court, in signing those, the court makes those compliance with those terms and conditions of probation an order of this court. The court acknowledges or makes note of the fact that the defendant has already signed those written terms and conditions of probation, acknowledging that she has read, understands, and will comply with the terms and conditions of probation. At this time, the court would order the defendant to meet with the probation officer to get set up on probation. You may be excused at this time to do so.